Hi, hello, good evening. This is James Iglol, and welcome to Wiser Pinoy TV. So, we have already done with part one and part two of our Criminology Lecture Book 1. So, as promised, I will be doing the part on Article 11 of Code, which is the justifying circumstances. Now, we have to take note that in nature, defensive acts, there must be always unlawful aggression. So, ito yung palagi nating tandaan dito that there must be unlawful aggression. The reasonableness of the means employed depends on the gravity of the aggression. So if it was done to save the life of the person life. So ito yung dapat nating always tandaan when we talk or when we speak about justifying circumstances under Article 11 of the Revised Penal Code. So if an act is categorized under the justified circumstances, the act is considered to be in accordance with law such that no criminal liability shall attach to the actor. So take note that this is a justifying circumstance. So wala itong ating criminal liability. So the actor likewise is free from any civil liability. So ang civil liability niya wala rin, except when it falls under the circumstances mentioned under paragraph 4 of Article 11. Later part, we will be discussing that, wherein it talks that the parties benefited from the act have to answer for the damage caused. So ito naman yun, sino yung niligtas, because we're talking about self-defense here, siya yung magbabayad ng civil liability under paragraph 4 of Article 11. Now let's talk about self-defense. Now in justifying circumstances, the most important is self-defense. So when this is given in the board exam, it is the element of unlawful aggression that is in issue. So ito yung pinaka main issue dito is the unlawful aggression. So never confuse unlawful aggression with provocation, because mere provocation is not enough. Take note of that. But mere provocation is not enough for you to kill someone, and then you will guide it under self-defense. That is not the rule. Now, you have to take note that under Article 11 of the Revised Penal Code, when we talk about self-defense, there must be three essential requisites that should be complied upon. One, unlawful aggression on the side of the victim, and second, reasonable necessity of the means employed to prevent or repel it from the person defending himself. So you have to take note and qualify of that. And lastly, lack of sufficient provocation on the part of the person defending himself. Meaning, kung ikaw yung nag-exercise ng self-defense, hindi ikaw yung reason o hindi mo provoke yung person para atakihin ka. So, dapat wala ka talagang ginawa para mas mag-qualify siya for self-defense. Now, take note that you cannot have self-defense whether complete or incomplete without unlawful aggression. So it's very important that unlawful aggression must be present as a matter of requisite when you speak of Article 11 of the Revised Penal Code. It has to be there all the time. Kung wala ang unlawful aggression, guys, you cannot even claim an incomplete self-defense. For the claim of self-defense is only valid when there is an unlawful aggression. Now, let's say, for example, why is self-defense allowed? Ito yung pinaka-main question natin sa batas natin na okay naman din siya, but why is that self-defense allowed? Ang first niya is that the state should be able to protect us. That is the main, one of the duties of state. That is to protect the people. Now, it is the duty of the state to protect its citizens. However, the state cannot be there 24/7. And so the state gives us the right. So another is the instinct for self-preservation. So it is natural to defend oneself from an attack for normal people. So when you are attacked, you have to defend yourself. Now, I will give you an illustration to this. So A and B are long-standing enemies. So si A at B, magkalaban na yan sila matagal na. Because of their continuous quarrel over a boundary of their adjoining properties, when A saw B one afternoon, he approached the latter in a menacing manner with a bolo, yung itak nga. So when he was about 5 feet away from B, B pulled out a revolver and shot A on the chest, killing him. So um, napatay ni B si A. So is B criminally liable? What crime was committed, if any? So kung nalito kayo sa illustration ko, you could actually rewind the video because after the live, this will be recorded, sa channel na ito. So you could actually view this again. So the act of A is nothing but a provocation. Okay, it cannot be characterized as an unlawful aggression because in criminal law, an unlawful aggression is an attack or a threatened attack which produces an imminent danger to the life and limb of one resorting to self-defense. So, klaro naman sa illustration na hindi naman yon unlawful aggression but a mere provocation. So, in the facts of the problem given, that was said what was said was that A was just merely holding a bolo. That bolo does not produce any real or imminent danger unless A raises his arm with the bolo. As long as that arm of A was down, holding the bolo, there is no imminent danger to the life or limb of B. Therefore, the act of B in shooting A is not justified. So you have to take note of that mere provocation is not enough for you to even use the incomplete self-defense. No? So defense of rights is included in the circumstances of defense, and so is defense honor. So there is a very popular case of this in U.S. versus Mateo. While a woman was sleeping, her sister and brother-in-law went to see a movie and came home late that evening. So the accused was already asleep. So he started feeling through the dark, and in the process, he awakened and accused. Believing that her honor was at stake, she got a pair of scissors and stabbed the man. So when the lights were turned on, she realized that she had stabbed her brother-in-law. So the accused claimed as having acted in self-defense of her honor and mistake of fact. So yun yung nangyari. She said that she believed that her own honor was at stake. It was held that the whole matter is purely her imagination. Touching the arm cannot produce such danger as would really be imminent to the honor of the woman. So you have to take note of this, guys, that apparently under the revised penal code, the honor of a woman in respect of her defense is equated with her virginity. So that is jurisprudential declaration. Okay. In another case, also in U.S. versus Haurige, it was held that it was not possible to rape the accused because the whole thing transpired in the church where there was so many people. Therefore, her availing of defense of honor is not tenable. She would not possibly be raped in that place. So ito yung case na nag-accuse siya in there was an attempt na rape siya inside of a church. So, sabi ng Supreme Court, it's very impossible. No? Defense of honor here is being equated with one of the abuse of chastity of a woman. In this case, the offended party placed his hand on the thigh of a woman who was then praying. So, grabe naman ito, no? So, there was already some sort of aggression, but it was not enough to warrant the act resorted to by accused in getting a small knife from her bag and thrusting it to the chest of offended party. So, no, hinawakan na yung legs niya, malapit na sa maselan parte ng katawan niya, and then kumuha siya ng kutsilyo sa bag niya, tapos in-stab niya yung offended party. So the Supreme Court also said that it was not enough. No? So do not confuse again with unlawful aggression with provocation. So what justifies the killing of a purpose unlawful aggression is that if the offender did not kill the aggressor, it will be his own life that will be lost. That will be the situation. So you have to be very specific on that. If that is not the situation, even there was an unlawful aggression that has already begun, you cannot invoke self-defense. Just like what the scenario of the case US versus Haurige happened. Okay. So let's proceed now to unlawful aggression from the part of the victim. Aggression is a physical act. So take note of that. So that's first. So physical assault, in the physical assault, let's say, um, hindi lang yan siya, ano ha, now in aggression, there must be a requirement and it should be unlawful. So you should distinguish the lawful from unlawful. So example, lawful aggression from lawful enforcement agencies are authorized to use such force as reasonably necessary to apprehend criminals. So when they attack the use of physical force that is not unlawful aggression, that is lawful. So you have to distinguish lawful from unlawful. So there are two kinds of aggression. There is actual and imminent. So example ng actual aggression. Number one, there is an example by Reyes ko, yung playful kick, na tinatawag natin. Yung example, barkada. Uy, bay, kumusta? Sabay sipa. That is not unlawful. Diba? Yung sasapakin ka bigla or sasampalin ka bigla. So that is actually not unlawful. So a mere push in a heated exchange of words, again, which is not unlawful. So let's say, for example, tinulak, nagkainitan ng salita, there was an exchange of words, no, hateful words, so tinulak. That was not also a unlawful aggression. Sampal is that unlawful aggression because the face represents the person and his dignity, etc., especially sa Chinese culture, no? So when you attack the face, hindi lang face ang ina-attack mo, kundi yung dignity niya. So that is unlawful aggression. So you have to take note of that. Sampal is a form of unlawful aggression. So there are principles with respect to unlawful aggression, guys. So the aggression must be continuous. So take note of that. In other words, if there is no more danger to life and limb, there is no basis for self-defense. So when the aggressor flees, no, unlawful aggression does not anymore exist. That is exactly what happened in the case of people versus Alcunga. No? The deceased was the one who first attacked the accused. However, having sustained several wounds, the deceased ran away, but he was followed by the accused, and another fight took place during which a mortal blow was delivered by the accused. So, patay, no? Kunga claimed self-defense, but the Supreme Court said that there is no self-defense here. During the first part of the fight, there could be self-defense. Kung doon siya napatay, but then there can be a valid claim for self-defense because there is unlawful aggression in the first part. Kasi wala siyang ginawa, nakaupo lang siya doon sa isang tabi, then he was attacked. Tapos dinaganan siya na tapos tumakbo yung aggressor. So there is no longer unlawful aggression because the principle of continuous was already violated under this situation or circumstance. So, wala nang actual or even imminent unlawful aggression kasi tumakbo na, no? Pag ganyan kasi parang retaliation na pag retaliation na hindi na siya self-defense. So, it was vindication or retaliation na nga. So, when you've already disarmed the aggressor, you need not kill him kasi nga wala nang danger. So the danger to life and limb has already ceased. So pag nawala na yung danger, there can be no unlawful aggression, and thus valid self-defense can no longer be invoked under the given circumstance. So second, there is no unlawful aggression when there is agreement to fight. Let's say we agreed to fight, no? For there to be self-defense, there must be no agreement to fight. Let's say, halika dito, magsuntukan tayo. So sabi mo, sige, suntukan tayo. So after that, napatay mo yung tao, so you cannot invoke for a valid self-defense because again, there is no unlawful aggression when there is agreement to fight. Okay? Okay. So let's punta naman tayo dun sa two kinds of punta tayo sa reasonable necessity, the second element, no? Reasonable necessity of the means employed to prevent or repeal it from the person defending himself. So take note of that. Ano itong it, na sinasabi dito sa provision. That is the unlawful aggression. So unlawful aggression is either actual or imminent. And from here, dalawa rin, one is to prevent. So what do you prevent? You prevent an unlawful or imminent unlawful aggression. Second is to repeal. No, when you say repeal, there is a presumption that there is an ongoing attack, an actual attack that you are repelling, and prevent naman is yung paano pa, ongoing pa. May maxim dito, necessitas non habet lehim, which means necessity knows no law. If you are under attack, you do not think of Article 6 and Article 11. You just defend yourself. Necessity knows no law. Ito yung sabi ng legal maxim natin. In time of danger, of emergency, now human nature does not act upon the process of normal reason, but in obedience of the instinct of preservation. So there are two kinds of reasonable necessity when we speak of that. One is necessity of the course of action itself, as the necessity of course of action, as in the case of People versus Alacunga, if you could recall, ang course of action niya, mali kasi wala nang necessity sa course of action niya because the unlawful aggressor already ceased or tumakbo na, no? Necessity of the means used. So you have to take note also that in US versus Apego case, a sleeping woman who was awakened by her brother-in-law grasping her arm, nagising siya, tapos meron siyang hinawakan na kutsilyo, tapos in-stab niya yung brother-in-law niya. So there was no necessity to employ the means used. Also in People versus Haurige, nasa church ang babae, hinawakan sa upper thigh. So ginawa ng babae, may balisong pala siya doon sa bag niya. So in-stab niya yung lalaki inside the church. So here, the Supreme Court considered the placing of the hand of the upper thigh as unlawful aggressor. However, the means used was not reasonable. So you have to take note of that the means employed on the part of the person defending himself should be reasonable and germane. Kasi nga, first necessity knows no reason, and second, the person defending it is not expected to control his blow. So if you control your blow, you are endangering yourself actually kasi yung kalaban mo hindi din nagko-control. So just like a shooting, when you draw your gun, be sure to fire kasi kung hindi ka ready pumatay, wag mo na lang ilabas ang baril mo. So ganyan yan yung principle natin. So ganyan, hindi ka expected to control your blow kasi there is danger to your life and limb. Kung hindi na control, that is not the fault of the person defending. That is the human nature and the law recognizes that because reasonable naman din yung law natin. Just take note, guys, of the rule that perfect equality is not required. So if you were attacked using a pencil, you should also attack using pencil. No? So hindi required yan, yung concept na yan. So again, necessity knows no law. What the law requires is only rational equivalence, hindi perfect equality. Such as si Pacquiao, ang kasuntukan mo, hindi mo din pwede na suntukin mo lang. So rational equivalence in the consideration of what will enter as principal factor, the emergency, is the imminent danger to which the person attack is exposed. And the instinct, of course, take note that more than reason that moves or impels the defense and the proportionateness thereof does not depend upon the harm done, but rests upon imminent danger of such inquiry, as emphasized in People versus Encomienda. So it is the instinct more than reason. Okay. So okay na, if you were attacked, what will you do? Meron mga tao na tapang, so they stand their ground. But there are also na tatakbo, no? Tapos when you are cornered, then that is when you act. So there can be no claim of self-defense on that, both instances. So in the past, the rule is that you avoid or retreat to the wall, and only when you were cornered that you are allowed to claim self-defense. But in the recent cases or jurisprudence, hindi man kailangan tumakbo. Kung sinugod ka, then you defend yourself right there and then. No need to run. Okay. And also that reasonable necessity as a requirement is liberally construed in favor of the person defending in favor of the law-abiding citizen. So, kasi nga on the day as ruled by the Supreme Court, these are dangerous times. There are many lawless elements who kill for the thrill of killing. There is no adequate protection for the law-abiding citizen. So, when lawless person attacks on the streets of particularly in the victim's home, he should assume the risk of losing his life from the act of self-defense by firearm of his victim. Otherwise, the law-abiding citizen will be at the mercy of the lawless element. Hence, the requisite of reasonable necessity of the means employed to prevent or repel the unlawful aggression should, in these times of danger, be interpreted liberally in favor of the law-abiding citizens, as enshrined in the case of People versus Saw. Okay. Okay, let's proceed to the third element of valid self-defense. So the person, lack of sufficient provocation on the part of the person defending himself. So the person defending himself must not give any provocation. Ano bang ibig sabihin ng provocation? Ulitin natin. Ang ibig sabihin ng provocation is hindi mo siya trigger. Now, let's say for example, sinabihan mo siya na bobo. Pag sabi mo ng bobo sa kanya, nagalit siya, so inattack ka niya, tapos, of course, pag-attack niya, unlawful aggression na yon kasi pasugod na siya, tapos inunahan mo, binaril mo. So, may valid self-defense ba doon? Wala. Kasi, although there was unlawful aggression, pero take note, provoke mo siya. And the third element of a valid self-defense under Article 11 of the revised penal code is there must be a lack of sufficient provocation on the part of the person defending himself. So if it is given, it must not be sufficient. Okay? Even if there was provocation and if it was sufficient, this provocation was not given by the person defending himself. Take note of that also. So even if the provocation is present, it is not the proximate or immediate cause of the unlawful aggression or the attack. So example, there was a provocation but yet or proximate to the aggression. Okay, ito din yung difference niya no, sa general rule natin. Dapat walang provocation. Even if may provocation, pero ang layo na provoke siya ng ilan ng araw, so it's no longer a sufficient provocation. Okay? So if all the elements are present, there is a complete self-defense. Now, if kulang, not all the elements are present, depende yun ngayon, no? It depends. It may be incomplete self-defense, but always remember the first rule that there must be unlawful aggression. Because without unlawful aggression, there can never or there can be neither complete nor incomplete self-defense. So if incomplete self-defense, that there are two elements present and one of them is unlawful aggression, what is the effect, the legal effect? It is a mitigating circumstance. What kind of mitigating circumstance is this? So it is a privilege mitigating under Article 69, no, when we talk of penalty, when the crime committed is not wholly excusable. So there is an incomplete self-defense when not all of the three elements are present. To be specific, there is incomplete self-defense when only the first element of unlawful aggression is present, in which case the accused is entitled of 1 degree lower when we 1 degree lower kung darating na tayo sa islaw na topic. So if unlawful aggression and any of the two remaining elements are present, the accused is entitled for 2 degrees lower. So of person, defense against unlawful aggression, which is constitutive of crime against a person. No? So those are the very important thing. Now, when we talk about defense of property rights, this can only be invoked if the life and limb of the person making the defense is also the subject of unlawful aggression. So life cannot be equal to property. So take note of that. So if your property is being attacked, like there is no fencing and our property is affected, like in the case of Narvaez, no, People versus Narvaez. Narvaez was taking a rest when he woke up. He heard the walls of his house were being chiseled. So he arose and found that one of the laborers was indeed chiseling the wall of his house with a crowbar. So while deceased Robia was nailing the barbed wire and Davis was commanding his laborers, the accused pleaded to stop the fencing. However, they continued. So accused got his gun and shot Davis and Rubia. So there was unlawful aggression despite the fact that the invasion of his property right was not coupled with an attack against the accused. So take note of that. Now, how about on self-defense on libel? In this case, can he claim defense of his right under this paragraph? So the Supreme Court said yes, surprisingly. That was actually ruled as acting in defense of his property. But take note, guys, that there was no attack on the person. So according to Dean Inigo, if you claim right to property under this paragraph, the attack on property must be coupled with an attack on the person. So that is the case of Apolinar, according to Dean Inigo. So the Narvaez case is a stray decision because if you are going to talk about your right to property or you would like to defend your property, it is not under this paragraph, but a different paragraph of the law. Take note of the interesting rule on libel. Ang libel kasi guys, there is the so-called self-defense in libel. So if you are libeled, you may hit back with another libel. But there is a caveat to that. Take note of this. The caveat is the rest back or the libel that you hit back with should be related to the initial libel. Ano ba yung libel? It's a destruction of your honor of a person dead or no the memory through writing. No, take that of that writing. Okay. Kasi kung through words or spoken, that is under slander. Okay? Okay. So let's proceed now to defense of relative. So what are the requisites? Kanina, valid self-defense. Now, in our second topic natin ngayon is defense of a relative. So what are the requisites? You have URI. Kasi kanina, URL, no? URL yung valid self-defense. Ito namang defense of a relative, no? URI. So what are this URI? Unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. So third is in case the provocation was given by the person attacked that the one making the defense had no part therein. So when we talk about relatives who can be defended, we're referring to spouse, asawa, ascendants. Ano ba yung ibig sabihin ng ascendants? Ascendants is your apo or your great-great-grandchildren. Okay. So we're talking also about legitimate, natural, or adopted brothers and sisters or relatives by affinity in the same degrees. So death of a spouse terminates the relationship by affinity. So relatives by consanguinity within the fourth civil degree naman. No? So the fact that the relative defended gave provocation is immaterial. Okay. So defense of stranger. Anyone who acts in defense of the person or rights of a stranger provided that the following requisites concur. No, ito naman, we're talking about defense for stranger. Yung halimbawa, napadaan ka, may babae hindi mo kakilala, nire-rape. Okay. Question, tinulungan mo, napatay mo yung rapist. Ano man yung valid mo na defense. So yung defense mo ay defense for stranger para ma-justify yung pagpatay mo. So anyone who acts in defense of the person or rights of a stranger provided that the following requisites concur. So kung sa self-defense meron tayong URL at saka sa relatives URI, ito naman sa stranger is URT. URT stands for unlawful aggression, reasonable necessity of the means employed to prevent or repel it. And the third one is the person defending is not induced by revenge. Yes, may babae na nire-rape doon. Pagkita mo, uy, ito yung kalaban ko, galit na galit ako nito kasi kompetensya ko siya, so pinatay mo siya. So, na-violate mo yung third na requisite na dapat wala kang or hindi ka induced or hindi ka motivated ng paghihigante, galit mo at yung masamang balak mo sa tao. So, defense of rights, defense against unlawful aggression, which is constitutive of a crime involving the right of the defender, such in theft, acts of lasciviousness, and of course, libel. So, if a person being defended is already a second cousin you do not invoke defense of relative anymore. It will be the defense of a stranger. This is vital because if the person making the defense acted out of revenge, resentment of some evil motive is killing the aggressor, he cannot invoke a justifying circumstance. If the relative defendant is already stranger in the eyes of the law, on the other hand, if the relative defendant is still within the coverage of defense of the relative, even though he acted out some of evil motive, it would still apply. Okay? It is enough that there was unlawful aggression against the relative defendant. And that, okay? So let's talk about incomplete self-defense naman or incomplete justifying circumstance. Kasi nagiging incomplete ang self-defense mo if out of three, only two na elements lang. But take note ha, dapat present all the time, inevitably present itong unlawful aggression. Kasi pag hindi present ang unlawful aggression, such act is no longer justified or kahit na nga incomplete defense, eh hindi siya pwede. Now, when you say incomplete justifying circumstances, it means that not all the requisites to justify the act present or not the requisite to exempt from criminal liability are present. How, if at all, my incomplete self-defense affect the criminal liability of offender? Again, if at all, may incomplete self-defense affect the criminal liability of the offender? If the question specifically refers to the incomplete self-defense, then defense of a relative or defense of a stranger, you have to qualify your answer. First, to have incomplete self-defense, the offended party must be guilty of unlawful aggression. Without this, there can be no incomplete self-defense, defense of relatives, or defense of strangers. Second, if only the element of unlawful aggression is present, the other requisites being absent, the offender shall be given only the benefit of an ordinary mitigating circumstance. However, if dalawa ang present, one is unlawful aggression, then the offender can be given now the benefit of the benefit of a privileged mitigating circumstance, wherein in effect to that, two lower degrees siya kung i-apply natin yung intermediate na sentence law. Okay. Third, if aside from the element of unlawful aggression, another requisite but not all are present, the offender shall be given the benefit of a privileged mitigating circumstance. So, yun sinabi ko kanina. In such case, the impossible penalty shall be reduced by 1-2 degrees depending upon how the court regards the importance of the requisite present or absent. So if the question refers generally justifying or exempting circumstances, the question should be how may incomplete justifying circumstance affect criminal liability of the offender, if at all? Okay, you have to make a separate answer with respect to self-defense. So defense of relative or defense of stranger, because in these cases, you always have to specify the element of unlawful aggression. Otherwise, there would be no incomplete self-defense because self-defense of relative or defense of stranger in general, with respect to another circumstances, you need only to say this. If less than a majority of the requisites necessary to justify the act or exempt from criminal liability are present, the offender shall only be entitled to an ordinary mitigating circumstances. But if the majority of the requisites needed to justify the act or exempt from criminal liability are present, the offender shall be given the benefit of a privileged mitigating circumstance. The penalty shall be lowered by 1 or 2 degrees when there are two conditions to justify the act or to exempt from criminal liability. So the presence of one shall be regarded as the majority. Okay? Okay, so I hope you are able to, what do you call this, learn something. So let's check kung meron bang comments dito, no? So, okay. So let's continue on the state of necessity. Now, let's try to understand what is state of necessity. The state of necessity must not have been created by one invoking the justifying circumstances. What I mean is, for example, A drove his car beyond the speed limit so much so that when he reached the curve, his vehicle skidded towards the ravine. No, he swerved his car towards a house, destroying it and killing the occupant therein. So, ang lakas-lakas ng pagka-drive ni A, tapos pagdating niya doon sa may kurbada, dumiretso siya, pumunta siya doon sa bahay, nasira niya yung bahay, at napatay na yung mga tao na nakatira doon. A cannot be justified because the state of necessity was brought about by his felonious act. Kasi naglagpas siya sa speed limit and hindi na justifiable or reasonable yung speed ng or mechanism ng pagdadrive niya. Now, the civil liability referred to in the state of necessity is based not on the act committed but on the benefit derived from the state of necessity. So the accused will not be civilly liable if he did not receive any benefit out of the state of necessity. On the other hand, the persons who did not participate in the damage or injury would be pro tanto civilly liable if they derive benefit out of the state of necessity. So in another words, civil liability is based on the benefit derived and not on the act damage or injury caused. So it is wrong to treat this as an exemption to the rule that in justifying circumstances, there is no criminal or civil liability on the principle that no one should enrich himself at the expense of another. Okay, so that's very self-explanatory, guys. Now, on the other hand, when we talk about fulfillment of duty, in the justifying circumstances of a person having acted out of fulfillment of duty and the lawful exercise of right or office, there are only two conditions that you need to meet. One, the felony was committed while the offender was in fulfillment of the duty or in the lawful exercise of the or, right or office. And second, resulting felony is unavoidable consequence of the due fulfillment of the duty or the lawful exercise of the right of office. So invariably, no, take note of this, guys. When you are given a problem on this premise and the first condition is present, but the second is not, the offender acted with culpa or negligence, the offender will be entitled to a privileged mitigating circumstance. This is what you call incomplete justification of fulfillment of duty or incomplete justification exercise of a right. In that case, the penalty would be reduced by 1 or 2 degrees. So, in People versus Uwanes and Calianta, the accused chief of police and the constabulary soldier were sent out to arrest a certain balagtas. So, supposedly a notorious bandit. There was an order to kill Balagtas if he would resist. So that was the condition. The accused arrived at the house of the dancer who was supposedly the girlfriend of Balagtas. When they were there, they saw a certain person who resembled Balagtas in all his bodily appearance. So may kamukha yung accused na sana i-arrest nila. No, who was sleeping on the bamboo bed but facing the other direction. So the accused, without going around the house, started firing at the man. So pinatay niya yun, no? Binaril. They found out later that the man was not really balagtas. So they tried to invoke the justifying circumstance of having acted in fulfillment of duty. So the second requisite is absent because they acted with negligence or culpa. There was nothing that prevented them from looking around the house and looking at the face of the fellow who was sleeping. There could not be any danger to their life and limb. Hence, they were held guilty of the crime of murder because the fellow was killed when he was sleeping and totally defenseless. However, the Supreme Court granted them the benefit of incomplete justification of fulfillment of duty, and the penalty was reduced to 1 or 2 degrees. So take note that you should not confuse fulfillment of duty with self defense. Okay? So, I think that would be enough for Article 11. I hope meron kayong nakuha. So, we will be continuing this lecture series, and we will start next time, or the part 4, on Article 12, which is the exempting circumstances. And we will try to relate that one with the Juvenile Justice and Welfare Act of um, Act or the Republic Act 9344. So thank you very much for watching, and thank you very much for watching, and welcome to my channel, which is the Wiser Pinoy TV. So do not forget to subscribe, like, and share the video to those criminology licensure examination takers, maybe this year or next year. So God bless, and thank you very much.